Thank you very much. And thank you everyone for attending. We're going to cover over the next sort of hour or so, principally three areas between Adam and I. I'm going to touch firstly on wills. I'm also going to say a little bit about trusts and end up just mentioning lasting powers of attorney. And Adam will then pick up the areas around appointees and the court of protection and the role of a deputy. I should say that when I was sort of thinking about how to present today, I'm very conscious that many of you listening have got very varied knowledge about wills and tax planning, inheritance tax and trusts. So do forgive me if some of the things I say are very familiar to you and others seem a little bit more obscure. What I'm not planning to do is to give you tax planning advice. What I hope this evening does achieve is to give you some thoughts about when may be the right time to take advice. I'm very conscious that lawyers are expensive and taking advice is a big decision. I'm also very conscious that you can now get an awful lot of documents online. You can create documents through ChatGPT or an AI. And the combination of the two often leads a lot of people to either not do anything or to prepare their own documents. Now, I have no issue with that, but I think there are times, particularly with vulnerable people, with complicated tax matters, when advice can be valuable. And often it's the advice that you're paying for. It is actually the advice rather than the document that you are paying for, and which hopefully will create peace of mind for you and make sure that your affairs and your loved ones' affairs are in order for the years to come. I should also say that these areas that we're discussing today, whether it's wills or whether it's lasting powers of attorney or court of protection, are all very specialist legal areas in their own right. I work for a large law firm, and within the law firm, we have specialists who focus on agricultural tax planning, on elderly care, on trusts, on business property relief. So the days of having one solicitor or lawyer that might be able to cover all your legal affairs are somewhat behind us now. The areas are so complicated and some of the legislation is so wide that nowadays one tends to have, as I say, within a law firm, rather than a private client lawyer, specialists within these particular fields. And the court of protection is one of those fields, as well as tax planning. I think one of the struggles with advice is where to go for advice. And, you know, outside of a firm like ours, like Clark Wilmot, I think the key is to try and find the right specialists. There are organizations, and one of the legal ones for tax planning and advice is called STEP, S-T-E-P. There's another called Lifetime Lawyers, both of which have got accreditation and proper panels and scrutiny as to the people that they allow on with the relevant expertise. I'm also conscious that charities often are a very good source of information about good advice. So firstly, I think recognizing when you need advice, and secondly, finding the right advisor and not being embarrassed about asking around and you know, asking about cost. All of those things I think are perfectly you know, one needs to be perfectly happy to ask those questions and then make your decisions. Very briefly, I've been I'm very glad that the picture on the last slides has just switched by, because as you'll see, I that must have been taken some 15 years ago, but it does remind me that I have been at Clark Wilmot for 27 years and as you may know, is a legal firm based in Taunton and wider nationally. And we cover all sort of legal services. But as I say, my particular expertise, very similar to Adam's, who will speak next, is around the court of protection. So as I just mentioned, I think there are three areas that I'm going to touch on. The first being wills. And this is possibly one of the slides that I hope many of you attending will be familiar with. And it really sums up the situation if you do not make a will. And as set out there, what happens when you pass follows the intestacy rules. Those rules dictate who receives your estate. And the only exceptions to that will be assets that are held jointly, and therefore something like a jointly held bank account does not follow the intestacy rules. A house held jointly rather than as a tenant in common will not pass in the intestacy rules. But I think that the main point is that the intestacy rules will largely determine what happens to your estate, and it is out of your control. And I think one of the particular bullet points there that resonates is that if you have a cohabiting partner, there is no automatic provision for them at all, which obviously could be very distressing. We'll talk a little bit in a minute about disputes over estates. And I think it is the unpredictability around the intestacy rules about what will happen after you've gone, who will sort out your affairs, what the tax bill might look like, and who is going to get what, which can be very unsettling for families. So just then moving on to look at the actual outline of the intestacy rules. I hear a lot of people tell me what they think the intestacy rules are, and here is a very brief outline as the rules currently stand. Many people say to me that if you die without a will, everything goes to the Crown, or to, as was the Duchy of Cornwall. But as you will see, that is a very long stop and is actually very unlikely. The main provisions are set out there for if you're married with children or you're married without children. And as I say, not being married does leave the cohabiting partner in a very difficult situation. The real point of this slide is that those rules may not be, and they may not provide for what you want to do with your estate after you've passed on. And the intestacy rules are very rigid, and the cost of resolving problems with the intestacy rules can be considerate. So I suppose that brings me on to what I would describe as the power of a well-drafted will. Unlike the intestacy rules, which sets out all the provision for you, these bullet points really cover some of the benefits of having a properly drafted will. As you'll see, and probably are familiar, the role of an executor, for instance, is an incredibly important role. An executor will make sure that your estate is in order, that your wishes as set out in your will are considered and executed, and will guide the family through a very difficult time. So the time to think about when you are drafting a will, finding an appropriate executor, thinking about the right sort of person who can fill that role. It may be a lawyer, but it may not be a lawyer. I'm very open-minded about whether you should have a lawyer as an executor or not. It is up to the executor, if it is not a lawyer, to talk to a lawyer if they need to get advice. We'll also come on in a minute to talk about trusts, and often a will create a trust within it. So a will might leave something to somebody outright. You might gift some money or an asset to a member of the family. But there might be reasons that you don't want to gift something outright to a member of the family, and you actually might want to put it into this structure that we call a trust. And after all the administration and the probate has been sorted out, it will be the trustee that then oversees that asset and follows your wishes in relation to that trust, which may be created in the will. Another reason where I think taking advice and really thinking hard about putting in place a will is around asset protection and spouses, and particularly, as we'll look at on the next slide, if one's for second marriages, where one's got more complicated family situations, a well-drafted will can relieve a lot of anxieties for families. Asset protection for children. I have 2 young adult children, and the years ahead, I hope, are straight, but one never knows what might come along in terms of their attitude towards risk, whether they're going to be able to manage money, their relationships, their business dealings, and whether they are going to take undue risks. And a properly drafted will can help protect assets going down to children to make sure that they are overseen rather than given outright to young adults or children or older adults, to make sure that those assets are not lost through any of those type of issues around debt, divorce, or bankruptcy. It can help with IHT savings. And there are well set out IHT exemptions, and we'll look at a few in a minute. As I say, I'm not planning to give tax advice. This isn't about tax avoidance. I get through my post regularly invitations to seminars to put houses into trusts or attend an event that will help with my care fees and not paying care fees. Those schemes are often very risky and, in my view, should be avoided. The tax repercussions of those schemes, let alone the purpose of those schemes, very often unravel, and they can be very expensive. But taking advice, particularly if you are likely to pay tax, and talking to the right person about making legitimate IHT decisions, is a very sensible step to take. Scope for family disharmony minimized. Many of you will probably have seen from the newspapers, but one of the fastest growing areas of law is around litigation around wills. Every day there is a report in the newspaper about a family that are at war in the courts, looking to argue about a legacy or a will. The cost to the family and to the fabric of a family, as well as to the financial repercussion of that litigation, is very significant. Very often, when a family have an argument over a will, all the family members will be represented by solicitors and barristers. And the cost of that can regularly exceed a 6-figure sum very easily. So while the cost of a well-drafted will is unwelcome, if there are dynamics within a family or concerns within a family, then taking that advice may well be a good investment for your family further down the line. Finally, flexibility and control. A will doesn't need to leave everything, as I've said, outright to the beneficiaries. It can create within it a trust, which is a mechanism to hold assets and to hold them so that the trustees can see how things develop for family members. And that might be for a vulnerable family member who might it'd be too early to tell how long, how well they're going to be able to manage money, for instance. Or, as I've said, it may be for uh, a good idea for someone who is young, who's inherited early, or someone who may not, as I say, manage money well at all in any event. Just moving on to the comment I made about the different types of wills. There isn't one will. And this is why it's very confusing. And I'm very mindful that lawyers tend to use legal jargon, and that in itself can become impenetrable and very confusing. There are simple wills. There are wills setting up discretionary trusts, life interest trusts. There are wills designed for people who've got business assets or agricultural property. But as I've said earlier, I think one of the most important areas for a will sometimes is when one has an extended family. It may be that somebody's been married twice. There may be children involved from two different families. And that is an extremely good time and opportunity, I think, to take advice around getting a proper structured will that supports the spouse after the first has passed on, but also then remains very fair to the children from the two different families. So that's one type of will and one type of scenario, as I say, where advice may well be welcome. Another area we've touched on is providing for your offspring. And it's back to the comment I make about leaving everything, and it can be significant sums of money to young adults or children or those who may not be able to manage. And I'm very mindful here of that group there around vulnerable beneficiaries. Both Adam and I deal with children and adults who are not able to manage their financial affairs. They don't have the mental capacity to manage their financial affairs, and therefore actually leaving monies outright to people in that situation creates a problem. They're not able to manage it, and in turn then an application will be needed to the Court of Protection to appoint someone to manage that money. So that's a sort of situation where taking advice around setting up a disabled persons trust or a discretionary trust or some form of trust that preempts that step and makes sure that the vulnerable beneficiary does receive their share of any legacy, but receives it in a way that is managed well and sensibly, is there for them, and it is thought through in terms of issues around things like benefits and the impact on benefits. These are legitimate conversations to be had around advice. And as I say, these are very different conversations to tax avoidance type conversations. Trust planning in your will is a significant area. And as I say, there are many different types of trusts for different types of scenario. And I don't want to overcomplicate it. But what I would say is that the tax treatment of those different trusts needs to be understood. Tax is payable if you put money into trusts, but it is payable in different ways, and there are different rules on the various trusts. So, as I say, if you're thinking about putting in place a will, and that will may benefit a vulnerable beneficiary and might involve setting up a trust, it is an area where I would be strongly suggesting that you take advice. I'm just going to skip through 3 slides here. As I say, there are, and many of you will be familiar with the ground rules around inheritance tax. And you'll see there on the green slide at the bottom, the most recent developments come in around pension pots and inheritance tax. These rules and ideas around inheritance tax need to be understood if you are going to benefit from them. And there are people often try to save inheritance tax by, for instance, giving their house to their children, but then they remain in the house, and that is called a gift with reservation of benefit, and it won't work. So understanding exactly how you set up your estate and your spouse, with your spouse and your family, to make use of your allowances and make sure that you get the benefit of them is another area where, if you've got an estate that has, it may have business assets, it might have agricultural assets, it may have just simply sufficient capital and property to mean that you're going to pay inheritance tax, it may well be advisable to take advice, as I say, to try and see how that can be minimised. And I think all of you will be aware of the recent changes around not only pensions, but also agricultural property relief that are causing a stir at the moment following the last budget. So that is my canter through the world of wills. And as I say, I think the main points I'd like to reiterate are, it is often the advice around the will that is as important as the document. And I do appreciate that advice is expensive. Try and find the right expert. Do ask around. I hope I've flagged up a few areas where I see quite often disharmony and problems, whether it's through intestacy or second marriages or around vulnerable beneficiaries, where I think that advice is particularly valuable. I just now want to very quickly discuss lasting powers of attorney. I very often give a talk in a room and ask the people in the room to put their hand up if they've got a lasting power of attorney, and it's always very few people. And I think it's one of those things that we all know we should do, but quite often we don't get around to doing it. Again, there's the cost of it, there's the forms, there's the time it takes, and we're all busy and we've all got plenty of other things to do. What I would say, and I'll wait for you to listen through to Adam, who's going to speak next about the Court of Protection, that if there's one thing I think to reflect on about putting in place a lasting power of attorney, the important thing is to reflect on what happens if you don't, and you lose your mental capacity, and an application is needed to the Court of Protection to appoint someone to fill that role for you. And when I think Adam explains what he does and what is involved and how long it takes and what the cost is, I hope it might tip some of you listening to feel that actually making the effort to put in place a lasting power of attorney now is actually a good investment, rather than, I very much hope you won't need either, but risk it if you do, having to apply, or someone having to apply, it won't be you, for a deputy to be appointed in the Court of Protection. So a lasting power of attorney, and there are 2 types of lasting power of attorney, one relating to finance and one relating to health and welfare. I'm really focusing on the lasting power of attorney in relation to finance. And what one can find is that if something happens to you and these are often unexpected, traumatic health issues that one is left in a position where one needs someone to help with one's financial affairs to make sure that the proper provision is put in place to support you. It may be in older age that one has a stroke or an accident, and somebody needs then to make sure there's money's available to provide support and pay for care and pay the bills. A lasting power of attorney puts that provision in place so that if something happens to you, there is someone there who can step in and pick up the reins and support you. And the benefit is it is somebody who you are very likely to be familiar with, maybe your spouse, maybe a friend, who you may have talked to about your affairs and can pick up the reins and help you immediately. A lasting power of attorney does need to be registered with banks and with other service providers, but the delay is relatively short compared with the lengthy court application procedure around the court of protection. It is a delay of some weeks rather than months. And an attorney is relatively free to get on and support the individual. With the court of protection, there is an awful lot of administration and paperwork, which is understandable and creates great accountability, but it is also an awful lot of work that is needed, which often needs professional help. So I hope once you've listened to Adam that you might come back to think about a lasting power of attorney and think, actually, I'll bite the bullet and I will put that provision in place. And the next slide, I'm afraid, paints the unpredictable picture of things that happen in life that no one ever expected, and tragically can lead to a need for a lasting power of attorney to be used. So looking at making a power of attorney, I said at the beginning of this seminar that I wanted to flag up when I think it's a good idea to take advice. And I should say that I think there are times when looking at making a power of attorney is something that you can do yourself without a solicitor. And I've put on the slide there the link to the government website, which will set out the process for you to be able to prepare and execute the lasting power of attorney online. And that document, once it is prepared, is registered with the Office of the Public Guardian. And the Office of the Public Guardian supervises attorneys, it supervises deputies, it has oversight of what attorneys and deputies are doing on behalf of the donee who has created the document, or on behalf of the individual that the deputy is acting for. So, for instance, the Office of the Public Guardian will investigate if people have got concerns about how an attorney is acting on behalf of somebody. So in this instance, once this document is created, it is registered with the Office of the Public Guardian. There is a fee of £82, although there are instances where that fee can be rebated, and it takes about 10 weeks to register the document. So it is a document that you can prepare and do yourself. It may be a document that you want some thoughts and advice from a solicitor. Choosing an attorney is a really important issue for you to think about. I hate to say it, but there is an awful lot of abuse by attorneys, and the Office of the Public Guardian regularly steps in, and I probably receive a call once every 3-4 weeks from the Office of the Public Guardian asking me to take over from an attorney who has unfortunately not acted in the best interests of the donor. So taking advice about the right person to be your attorney taking advice about the powers that you want to give to the attorney, when you want them to act. Often that will be only when you've lost capacity, how you want them to act, investment decisions, whether you've got any strong feelings about investments or how monies are invested and taking investment advice, etc., are all things that advice will cover off and may give you peace of mind. But this link here, and hopefully this outline, will give you the starting point if you would like to put one in place for yourself. So I hope that gives you a canter through wills, how within a will you can create a trust, and all of those can be extremely beneficial, can give you a lot of peace of mind, particularly dealing with a vulnerable beneficiary, and also give you a little prompt to think about making a lasting power of attorney once you've heard from Adam, who I'm happy to pass over to next to explain the role of a deputy and the court of protection. And I finish there with a slide. You are very welcome to email me if you have any questions. If you would like to follow up on anything, please do get in touch, and I'll be very happy to try and help. Thank you very much. I'll hand over to you, Ella.
Hello, everyone. I believe Adam is ready to start his presentation now. There we go. Hope you enjoyed Anthony's presentation, and I'll pass on to Adam now.
Hi, everyone. Thanks, Anthony. Always a pleasure to hear your talk. Oh, sorry about my lighting. I do apologise. I've gone in the dark. I'll continue on. So my section of this webinar is very much around what happens if, as Anthony was talking about there, you haven't, there is no lasting power of attorney in place, or one hasn't been made. And I just sort of overlap what Anthony said there, and probably one of the key parts about the benefits of a lasting power of attorney is that you get to choose who's going to manage your finances and affairs if in the event of you losing the ability to do that yourself. And that person is going to hopefully know you the best, understands your wishes, feelings, historical, your history around how you, where you went on holiday, what you like to buy, everything about you, really. So having that ability to choose that person is really, really important, because as Anthony was touching on there, the alternative, if there is no lasting power of attorney in place, and you do unfortunately lose capacity to manage your finances, then an application to the court of protection is required. Now, hopefully, that's by a loved one or a friend, and they can make that application to the court, and that's known as a lay deputy. The alternatives to a lay deputy is somebody like Anthony at Clark Wilmot, who is a professional deputy, or a public authority deputy, such as Somerset Council. So those, while are options, obviously Anthony and myself and my the service that I manage, we don't know the individual as well as somebody who that person chose. So it's a safeguard, but it's probably not the best choice. But it is there and it is available. And from a lay deputy, to make an application for a deputyship to the court of protection, as Anthony was saying, the timescales vary dramatically from a lasting power of attorney. So currently, an application to the court of protection is probably going to take 6 months. And initially the forms look quite daunting to make an application to the court protection, but there is support and help available. There is also a fee to make that application. It's currently £408. But as Anthony said, same with lasting power of attorney. In some instances, that fee is refundable, and it is the individual you're making the application on behalf. They are liable for that fee. So that's not something that if you pay, you are able to claim that back once you actually have access to the individual's funds. Because I know that is something that when we're talking to families, that is one thing that they are quite wary of. Also, as Anthony alluded to as well, some solicitors can be expensive as well. I've heard charges of sort of £3,000 to make a deputyship application. So I think with some support, and there is support out there, you are able to make the application yourself. For a deputy, in essence, it gives the individual who's made the application complete control over somebody's finances. So in effect, you are becoming that individual financially. It allows you to access bank accounts, pensions, occupational pensions, state benefits, investments. You can manage an individual's property. The only thing you can't do is a divorce. You can do statutory will, but it's a very, very powerful order that somebody is taking on, and needs to be, because financial institutions will not deal with or not allow you to deal with somebody's affairs without that order. But it might not always be the right order to apply for, depending on the individual. So if the person that you're looking after doesn't have complex finances, maybe is a younger individual, and may only have ever had state benefits, you may well be able to just make an application to the Department of Work and Pensions for an appointeeship. There's no charge for an appointeeship. It's a relatively straightforward application. It's actually done over the telephone. You can ring the Department of Work and Pensions, and they will actually come and visit you, and they will go through the application with you, and that will then allow you to administer an individual's benefits to make sure that you can pay for any care that they might receive, and sort of spending day-to-day items that they might wish. You can open up an account. It would be in your own name, but it's for the individual, and as money goes in there from the Department of Work and Pensions, it's got their national insurance number, so it's very clear whose money it is. And in a lot of cases, actually an appointeeship can work. Where we're looking at more complex finances, though, it is an application to the court protection. So if you're the individual that you're looking after, or you're looking to make the application, is in receipt of any care from the local authority, has a social worker, then you can actually liaise with the social worker. We have a liaison in the authority now. It's recently changed. It's someone called Lauren Gillum now, and they will actually talk you through the application process, and they will keep in touch with you, and as you get the order, they will then arrange for a financial assessment to be done, and invoicing of care if there is care in place. And that individual then will sort of work with you regards that. For individuals where there isn't a person that can take on that role, then, as I said, it may well be a professional deputy, such as Anthony, and that's known as a panel deputy. That is actually the court protection have a pool of panel deputies they can use, or it may well be the local authority. So the service that I look after, which is the client finances team, and we are very much the last resort where there is nobody else that can assist and support that individual. We're a very small team. We're located in County Hall in Taunton, and it is our role really to make an application to the court protection if that's required, so that we can then help and support that individual. And we'll get referrals where individuals unfortunately have suffered financial abuse. That may well be from a previous attorney. It may well be from a family member. It may well be that somebody in a later life dementia and they're on their own and nobody else is there to help and support them. So we may well get a application for that. And what it means is that, we essentially become that individual, and we will support then, whether that's paying for care, making sure that personal spends are available, clothing, everything that you and I do with our money. We are there to try and support that individual. Of course, we're a public body, so using private individuals' money is very heavily audited, and it's quite a restricted and restrictive process that we have. Just to sort of give you an idea, when I'm audited, an auditor once asked me, when we were looking through somebody's spending, I see that they bought a coffee there. Have you got the receipt for that coffee? And so the expectation from an auditor is, yes, you would have a receipt for a coffee. In real life, that is just not practical. And we would never ask care support teams to supply us with receipts for coffee. We do ask receipts for a lot of things, and we do ask for personal spending sheets to make sure that the money that we're making available is used appropriately and in the individual's best interests. We do visit our clients where we're deputy, and we as part of the court protection, we have a set of deputy standards that we must adhere to. And that really helps us to try and get to know the individual, because again, we're isolated at County Hall or working from home, so we don't know the individuals as well as a lasting power of attorney would. So everything that we do, we need to have quite a lot of information before we're able to make decisions, and so that is a delay as well in itself. We also look after quite a lot of people as an appointee. So again, people that don't have very complex finances, but still, they still have the same requirements a lot of the time as people with deputyship. So they may well be living in the community, maybe in a supported living environment, a shared lives, maybe on their own. And actually, we can make sure that they're receiving the correct benefits, making sure their housing benefit is in place, making sure they're paying their rent. We can deal with a lot of utility companies now as an appointee, as a public authority. And then it's making money available, and that in itself can be quite a challenge. I think pre-COVID, everything we did was people had to use actual money, cash. So they would have to go to the bank, and either the individual or their support teams would need to go to the bank to pick up money, which again, I can't remember the last time I actually paid for anything in actual money. So but we've been able to source a what's called like a prepaid card a scheme now for a lot of our clients, so that at least allows them a little bit more flexibility to use their money, so it's less restrictive. So we're always trying to look for the least restrictive options. Appointeeship does have limitations, though, as it says there. When we have an appointee, depending on the individual, we may look in the future. So if they receive an inheritance, we may then have to move over to become deputy for that individual, because then that allows us to deal with solicitor, and then actually what we do with that inheritance with regards to making sure it's got the best return for that individual and is obviously the most sustainable. As appointee, though, we're allowed to deal with motability, and if it, again, we look at the sustainability of a motability car for some individuals, it does impact their the benefits that they receive. So one of the things that my team will do is just make sure that from a long-term point of view, it is sustainable, and a lot of the times we'll actually trial those things. But so it's we're a very small resource, as I said. I think there's about 7 officers now, and we probably look after close to 400 individuals, both in deputy and appointeeship, and we probably have a waiting list for a further 60 that at the moment we haven't got the resource currently to be able to help. Something else that we look after is the ability to sign tenancies. So where an individual has somebody that has an appointee, but they need to sign a tenancy agreement, appointee won't give you that authority. A deputy will, but the individual doesn't require a full deputyship order. So sometimes we can actually make a request to the Court of Protection for an order purely to sign a tenancy agreement. So when you're thinking about any particular, or what particular type of authority you may need to support the individual that you're looking after, maybe ask yourself, in their future, do you anticipate that they're going to need a tenancy signing? If so, then potentially a deputyship order would be the correct order to go for, because it will allow you, and you need to specify on the application that's needs to be included in a deputyship order. Certainly when like children moving through into adulthood, having access to bank accounts when a child turns 18, a lot of banks will not give you that access. So you need to, because it's seen as the individual, they become an adult. So you may well need to look at a deputyship, or look at how you structure those bank accounts before they turn 18, so that you've got access and you can best support those your children. There is a cost, unfortunately, to the service that we provide here at the authority, and it is actually set by the Office of the Public Guardian, which is the organisation Anthony said, as Anthony mentioned, that oversees lasting power of attorneys and all deputies. And so there is an annual fee, and you can see there we submit a report to the OPG annually, and if the individual has property, there's a property maintenance fee. So there is unfortunately and that is a sliding scale, and it is means tested. So depending on the savings that the individual has, they will pay on a scale that is set by the Office of the Public Guardian. Obviously, if you're a lay deputy, these fees you don't need to be charged. So that that's again another benefit for the individual if they can have someone they know. So obviously a power of attorney best, failing that deputyship. And we do also charge for our appointeeship. There are other organisations out there that provide appointeeship services. I think the Money Carer Foundation and DOSH, and I know that their fees are higher than the current fees that we charge here in the authority. And actually, we've finished a bit early. Has anybody got questions? I'm conscious that we didn't ask any questions after Anthony's presentation. Hello, is there any questions?
No questions have come through as of yet, Adam. So if anyone has any, please feel free. You can either put them in the Q&A chat area, or if you'd like to ask Adam personally, you can put your hand up. So that's by selecting the raise your hand icon at the top of your screen, and then you can ask Adam the question. We have a question from Diana. Let me just unmute you, Diana. So I'm going to allow your microphone and allow your camera. You should be able to turn them both on now.
I won't bother with the camera if that's all right. I'm at home and dishevelled.
No problem.
I just to say I used to be a money advisor at Citizens Advice a few years ago, and we did have some limited training on powers of attorney. I also did one myself for a parent, but I'm really unfamiliar with the deputy. What do most, just in very general terms, do you feel that people are aware of the deputies in general, or and do most people come to you for?
So I think most of the time people hear the term court protection.
Yes.
And so I get we get a lot through that say I need to apply for court of protection, not really knowing what court of protection is or what the authority actually gives you. It's an incredibly powerful. It's like me giving you my wallet and everything I have access to that and saying you can control all of that. Anytime I want anything, I'll come to you and ask. And so
Okay.
that's a very, very restrictive authority to have over somebody. And certainly we have more appointees at Somerset than we do deputies because of the restrictive nature of that authority. It's not an authority that we apply for lightly. It has to be it has to warrant, not only because of the restrictive nature, but also the costs associated with that. So I don't think a lot of people are aware of it. And if they go onto then the gov.uk website, which is a really good resource, it's not very. It becomes even scarier when you start looking at what they tell you, and then you look at the application process. And because of that, my service has actually we've got a pack that we can give to families and people that are interested or looking at making that application, and we have some specimen forms that we can give you so that hopefully it makes a bit more sense. And we have a few sort of guides too, what to do if you are going down the deputy route, and sometimes an appointeeship to start with, so that you have the access to. It's a much quicker way of supporting that individual with getting personal spends, because you can access the benefits much quicker, and then making the application for the court of protection, which, as I say, can take 6 months. So at least in that period you're still able to support. And actually sometimes you may find, actually I'm not sure I actually need that deputyship, depending on the individual's
Sure.
but there's a lot of advice out there. I mean, obviously there's firms like Clark Wilmot which will give advice. The client finances team are here. We also have Lauren, who is there to liaise with the public as well, to give advice. So there's a lot of help out there. Obviously yourselves, like Citizens Advice is a great place, and we send people there for advice a lot of the time as well. But
can I just ask something?
Yes.
Presumably the status, if somebody is applying within a couple, because sadly, does that happen commonly, or is it more just if
No,
there's
that
a couple?
happens.
It does, but as well as lasting power of attorney, which I'm more familiar with. What I was going to say in that connection, does it make any difference? Because I'm just very conscious of the rise of cohabiting couples, and that's what did happen at Citizens. The people not knowing the lack of rights they had when a cohabiting couple, somebody passed away. Does it impact
happens
on yours as well?
Yes. So we will get so something that we get is that we'll have an application to become involved with somebody's finances that has a partner that doesn't want to do it but have joint accounts. And we have to make them aware that if we become involved, we are then involved in their part of that joint account.
Right.
So
Interesting.
I'm not sure I would want a complete stranger all of a sudden having access. And also there's that belief that, oh, it's a joint account, so I can do whatever I want, when that other part of the account, the account holder has lost capacity. They can't go into the bank and make it a sole account. The banks won't allow that, and in a lot of cases the banks will actually freeze that account until somebody is then able to act on behalf of the other party. So even more important, why as a couple, having a lasting power of attorney in place just means that you register that, and then you can actually go take that to the bank, so that in the event of something happening, you can, it means that things aren't put on hold, and life can, continue to be move forward, and you have access to the account, and it's easier. Then you can make the account sole and do all the things you need to do. But yes, there is that sort of myth that, I can go in and just do that, and unfortunately the banks aren't able to make that happen. I only that because I used to be a bank manager as well, so that's I was a nice bank manager. But
thank you very much indeed. Thank you.
Thank you, Diana. We have a question from Michelle, which is, if you have already got power of attorney set up, does this override the need to apply for a court of protection or deputyship?
Correct. So a deputyship is only needed if there is no power of attorney in place and the individual doesn't have the capacity to choose who manages their finances. So, and this is where and capacity is always quite a difficult area, and it's quite grey. But a person can lack the capacity to manage their finances, but can still have capacity to choose who's going to look after it. So they might not be able to tell you all of their benefits or what they're entitled to or where everything is, but they can say, actually, I want that person to look after my money for me. And that can be the threshold to allow them to then set up a power of attorney. It's only when the individual doesn't have the capacity to make that choice that and there isn't a lasting power of attorney in place that then a deputyship application is required. So a little bit, that's quite a grey area, and a lot of people struggle with that.
Thank you, Adam. That's great. Does your team, by any chance, have a generic mailbox that people can go to?
Yes,
with
they
questions?
do, and it's not on there. So thank you for reminding me.
No problem.
It's all one word: client finances with an S team at somerset.gov.uk.
Okie doke, I'll pop that in the chat. So if anyone has any questions for Adam or his team, that goes to client finances team at somerset.gov.uk. Is that right, Adam?
Yeah.
Perfect.
Yeah.
I've posted that in the chat. Were there any final questions from anyone? No, it doesn't look like it. Well, I would like to first of all thank Adam and Anthony for their presentations this evening. They were fantastic. Really appreciate you taking the time to do them for us. Also, we'd like to thank all of you for coming. We really hope you enjoyed today's webinar and that you found it helpful. If possible, if you could please take the time to give us your feedback in the feedback form, which I'll be posting in the chat shortly, that would be gratefully appreciated. The next webinar in this series is called Financial Assessments for Care Funding. This will take place on Tuesday, the 4th of February from 6:30 to 8. So if you'd like to register for that webinar, I'll put the link in the chat for that one too. Finally, if you'd like to find out more about the care and support available from Adult Social Care, there's a range of further information available on our website, and I'm going to post a link in the chat for that too. Thanks so much, everyone. Really appreciate your time this evening.